Um, we have another extraordinary panel here. What a group we've assembled today. We're very fortunate. I'm Jonathan Rausch, as I've mentioned, with Governance Studies here at Brookings. I'm a senior fellow. Next to me is Nathan Diamond, who's something of an old friend by now. I won't emphasize the old. Executive Director of the Orthodox Union Advocacy Center. He and I have never discussed this bill or these events, so I have absolutely no idea what Nathan is going to say about the events in Utah. Next to Nathan is Sarah Warbelow. Very honored to have Sarah. She's the legal director of the Human Rights Campaign, which, as we'll discuss, has played a central role in the events that have unfolded in Utah since the LDS Church's announcement in January. And finally, at the far end, another longtime friend of mine on this issue, someone who's worked in the trenches in multiple states and who is just back, I guess, Saturday, from Utah, where she was in the trenches working on this bill. Robin Fretwell Wilson, Roger, and I'm not sure I'll pronounce this right, Stephanie Jocelyn, Professor of Law at University of Illinois College of Law. So I'm going to start with Sarah, because one of the interesting things that happened here is that this bill in Utah was warmly endorsed by the Human Rights Campaign just down the block. By warmly endorsed, I meant they said no downside, I think was the expression that was used. Why did HRC endorse this bill in Utah?
Sure. So this bill is appropriate and a solid piece of legislation for the state of Utah. And I can't emphasize that enough. It is not a model for the rest of the country. It is not a model for the federal government. As Cliff mentioned earlier, underlying non-discrimination protections for other classes, including race, sex, religion, and age, had carve-outs across the board for religious organizations. The goal of the Human Rights Campaign and many of our allies and other organizations is to ensure that LGBT people are treated the same as all other protected classes. And that's what happened here in Utah with regards to employment and housing.
Not a template, which is the next question I'm going to come to. What's good about this law? Why such an enthusiastic endorsement?
Right. It provides real needed protections for LGBT people in this moment. And one of the things I think it does particularly well is not even a direct consequence of the legislation, but that is to provide a path forward for LGBT youth growing up in Mormon homes whose parents have been struggling with how to accept their children. The church endorsing this legislation, I think, provides a critical path forward for embracing of LGBT youth. We know that when youth are rejected from their families, regardless of their family's background, they have higher rates of attempts of suicide, suicide ideation, abuse of drugs and alcohol, school dropout rates. And so this is going to have a dramatically positive impact on the LGBT youth of Utah.
Nathan Diamond, what was your reaction in your capacity at the Orthodox Union to this bill?
Well, I would say, first of all, thank you, Jonathan, and to Brookings for having us here. I would say we were very pleased that the religious liberty advocates and the LGBT rights advocates came together and struck a compromise. I cannot resist but noting, especially since you said we are old friends, that
and getting older by the minute.
And there must be something about mid-March, because March 13th, 2009 was when we last sat here and talked about the intersection of religious liberty and LGBT rights. We were particularly focused on marriage because you and a colleague had written a very notable op-ed in the New York Times. And what I said at the time was that before I thought it was premature to talk about marriage. People generally engage in a period of dating prior to marriage. And that the LGBT community and the religious liberty community had to go on a few dates before getting into the marriage topic. And that there, rather than going to the big issue of marriage, there was work to be done with regard to discrimination in the workplace that both religious people and gay people were encountering and still encounter, and other areas as well. So it's interesting to me that now, several years later, as the country is in a much different place on the marriage agenda itself, that Utah seems to have been engaging in the courtship and the dating period, not dealing with the big issue of marriage on some of the topics that are in this legislation. And I think that's a very productive model for a lot of reasons, including a model, at least in terms of approach, that Governor Leavitt talked about for folks here in Washington, D.C.
Do you like the bill?
It's a very good bill.
Could you see it as a template for other states?
It may or may not be a template for other states. I think I would definitely agree with what Governor Leavitt said. I think the template to be looked at is the religious liberty advocates and the gay rights advocates sitting down and trying to forge some compromise and a path forward rather than continuing to play the zero-sum game. And I'll say further that at least here in Washington at the federal level, the zero-sum game still prevails. And that's why you've seen ENDA in a perpetual stalemate. That's why you've seen workplace religious freedom legislation in a perpetual stalemate and some other things as well.
We'll come to that since, Nathan, you lobby the federal government. So, Robin, you've heard a couple people now say that this is not a template. You've worked in many states on other statutes. Do you think there's something here that can be built on? And if so, what is it? And if not, what are the obstacles?
So one thing to point out is that there are actually two sets of protections here, and they needed to go hand in hand. So you have the grand bargain bill, the trading of LGBT rights for some modest political speech protections that Cliff described already. And you have a second bill too, which is 297, and there's a handout that I created that tries to talk about those two together. But the second bill is an essential part of that package. Without the second bill, I don't think you have the first. And the reason I believe that, and the reason I think Utah is an important model, an important moment, I didn't realize that was 5 years ago that we were on that panel. But the reason this is an important pivot is because this is the first time that we have tried to have LGBT rights extended after the marriage right was granted. It's the first, so in the voluntary same-sex marriage states, which you see presented on this chart that I created, basically you had the blue state glide path. You first had LGBT protections, sexual orientation, non-discrimination protections in statewide law, and marriage followed. When marriage comes first, especially when it comes in a way that many people would see as non-democratic. I cannot tell you how often I heard that over the last 3 weeks. In Utah, people are in mourning about the fact that they lost on the marriage question. And now they are trying to do something that they believe is fundamentally right and decent for the LGBT community. But they also are concerned to preserve what they believe is the uniquely religious character of marriage. And 297 does that piece. The second bill does that piece. And I think if the religious right does not believe that it's going to have those protections as to marriage, it cannot push forward these other rights. They see them going hand in hand. So the reason it's a pivot is it's because this is the first time that has ever been tried. And I think together that package gives great assurances to religious believers that protecting LGBT people in the community is not meant to wash out the religious character of their own faith communities, and nor does it destroy the religious character of what they see as a sacrament.
So, in your opinion, can this kind of package be built on in other states, or is it more the kind of pathway that Governor Leavitt spoke of, where it's not this package, but it's a process?
Well, all respect to the governor.
Oh, let's mix it up.
Let's just say he's wrong. And the reason he's wrong is because 297 has to be a part of this deal. Without those marriage protections, you're going to have the process. People have to sit at the table and treat together. I get that. But if protections for the religious nature of marriage are not present, I don't think there's much of a discussion to be had. Just like, by the way, if the T is not there in LGBT, notice that derailed things in Michigan. If that's not there, The other side cannot come to the table and have this discussion either. So I completely agree with the governor about the fact that we cannot be playing zero-sum games, that is not going to be helpful or constructive. It's not going to help us call a truce in a culture war. But that said, just like the T is non-negotiable, am I right? Is it non-negotiable?
Non-negotiable.
Non-negotiable. Notice that the T is non-negotiable. Marriage and that uniquely religious character of marriage is non-negotiable. So that has to be there.
Just so folks know, it's complicated, so I may explain this wrong, but there are two bills that we're talking about. One is the main bill that you've heard about, the Grand Compromise, which has LGBT anti-discrimination protections plus religious liberty accommodations. There's a separate bill which does something interesting. Utah, you all correct me if I'm wrong, the experts are here, but Utah was not a state which had a right for people to go and get married. They could be turned down by clerks across the state. That's something that gay people would actually have to look at as Utah became a marriage state. What if the clerks just said, no, we won't do it? So they added a bill, SB 297, which did two things. It said, first, we will exempt particular clerks from having to marry couples against the clerk's religious belief. So that clerk could have an opt-out. But second, we will create an obligation on the part of the clerk's office to marry people, so that if the gay couple walks in, they may not get a particular officiant, but they will be able to get married. So you have an interesting balance there where the gay couple's right to marriage is assured, but the officiant's ability to exempt themselves individually is not. Has that been tried anywhere else? Does anyone know? Is that a first?
There are a number of states that have pieces of legislation pending addressing this question. I will say, though, it's not clear that those clerks in Utah could have turned away same-sex couples. That would have been a question for the courts. Certainly, an argument could be made that the clerk, as an agent of the state, was required under the Equal Protection Clause of the U.S. Constitution to treat all who came to their doors equally. And that's why we do see in Alabama where there are clerks who are refusing to marry both same-sex and opposite-sex couples in order to avoid having an equal protection issue.
Does legislation like this at least close the door to some of that long drawn-out litigation? Will it mean we have less protest by, clerks or whatever in Utah?
Provided that there are individuals who are actually providing the marriage licenses, it will likely deter litigation.
So what's been the reaction in the gay world to these developments? Has it turned any heads, changed any minds, or what?
So this secondary bill is a bit more troubling for the LGBT community, in large part because we didn't feel that we were equal partners at the table from the beginning, being able to have the conversations that needed to be had around the legislation. I think that it ended up in a position that was not nearly as upsetting as the original format that the bill arrived in the legislature in. And there are a number of provisions that are not dissimilar to provisions that the LGBT community worked out in other states when passing proactive marriage equality legislation, including a piece that was taken, I don't know if directly from Washington State, but certainly modeled after Washington State, that allows religious organizations to continue to limit for purposes of marriage-related counseling, marriage-related retreats, only to same-sex couples, opposite-sex couples.
I didn't mean to cabin the question just to SB 297. What's the reaction in the LGBT world to the whole bargain? Has it had an impact? Are people noticing? Does it make anything easier or harder anywhere else?
Everyone is absolutely noticing. I mean, I think that's one thing we can guarantee. The whole world is paying attention to this, or at least the United States. The reaction has been very mixed within the LGBT community. There are some advocates who actually were so anxious to have non-discrimination legislation that they probably would have accepted deals that Equality Utah and organizations like the Human Rights Campaign would not have accepted. There are those in the LGBT community who are upset by the compromise, though in large part I do believe that's because there's a misunderstanding about what existing Utah law does. So I think it really is very much a fundamental misunderstanding. It's going to present some real challenges moving forward. Our bottom line is that LGBT people should be treated the same as every other protected class, and that we should do no harm to any other protected class. Utah is fairly unique. I won't say it's the only one, but fairly unique in the way that it treats religious organizations. And so therefore, this can't be lifted and imported into a state like Michigan, for example, which has dramatically different treatment of religious organizations under existing law.
Will this build any increased trust in the gay community in terms of willingness to talk about religious accommodations, or will this be seen as kind of a one-off because of stuff that happened in Utah with the church? And you heard Ben McAdams talk about how much trust building had gone on. What's your take on that?
Yeah, I think that there will be a greater willingness to have these conversations. They are conversations that need to be had. They're not an endpoint, and that's why the Utah legislation can't be picked up as a model and used as is around the country. But I do think there's an understanding that we do need to come together and figure out path forward. The LGBT community does not oppose religious liberties. In fact, there are many in the LGBT community who have fought very hard for religious liberties, in part because we see ourselves as protecting our own religious liberties on these issues. So it's not a zero-sum game.
Nathan Diamond, same question for you. What's been the attention and reaction in your world to this, if any?
I'm going to define my world as those who engage in religious liberty advocacy, and people have noticed, and people I think are a little bit of an Alphonse Gaston moment, wondering is this a new chapter to re-engage with LGBT advocates around some of these questions, because there have been, at least at the federal level, there have been pieces of religious liberty legislation that at least in the past, HRC or other LGBT advocacy organizations have opposed, and not to say that they weren't against some components of religious liberty, but there were other components where we just couldn't bridge the divide and find a compromise, and so there have been instances where we've sort of checkmated the religious liberty community and the LGBT community, as I said before, have sort of checkmated each other out. So if this is a new opening to re-engage with that conversation, that's great.
So wait and see, but it's at least possible this might sort of reignite conversations. Mm-hmm. Doesn't change the underlying substantive positions, but it may open some dialogue.
I don't know that the Utah bill per se changes underlying substantive positions, and they certainly, and no piece of legislation certainly is going to change theological doctrines held by religious denominations that go back millennia. But in trying to navigate and negotiate, workable public policy and modus vivendi in a pluralistic democratic society like we have here in the United States, we have to all keep trying at that. But part of what has to happen here also, I think, is just like we have to not get lost in Utah-specific activity being, too much or too little a model for other things. I think it's also instructive to keep in mind that we can even in this arena get focused too much on only the debates around gay marriage or gay rights and religious liberty, because there are other models from other contexts to look at as well. You talked about, both of you talked about, okay, so what's our view of a marriage licensing clerk and whether or not an individual marriage licensing clerk has the ability to get, so to speak, a religious exemption from providing a license to a specific same-sex couple, so long as another marriage clerk is available to do that so the couple does get served. And that's a point of contentious debate. To borrow from a very different context, in the state of Washington, where physician-assisted suicide is legal, there is an absolute right for a pharmacist in the state of Washington to refuse to furnish somebody with a legally authorized assisted suicide prescription from an individual pharmacist giving that person that prescription, and there's absolutely no debate about it whatsoever. And there are many, many other examples of individual rights of conscience in other contexts where I think Americans in general feel that, oh yeah, that's appropriate. We shouldn't impose that on that person. This is a very fraught issue. And it's on the right side and on the left side. So we have to have a broader lens for some of these conversations.
Very important, yes.
It's
not just gay, it's not just marriage or LGBT. We're talking about abortion, or abortifacients.
Right.
And pharmacies and Hobby Lobby
and
comes
lawyers
into
working
this.
on death penalty cases, and lawyers working on, maybe this is a little dated now, tobacco litigation. I mean,
Yeah, I often comment sardonically on how much we LGBT people love being the canary in the mine shaft. The point of the spear of every culture war debate. It always starts with us, but it never seems to end with us. Another quick question before we move on, which is the previous panel for both of you, and then I want to go to Robin on something else. But the previous panel, I think it was Governor Levitt, emphasized the importance of simultaneity. You got to do the whole thing at once. Do you both think that's correct and important?
I think it's right within the context of the law that you're talking about. So if it is non-discrimination, it does make sense to address where the lines and limitations, and to the extent, I don't believe that there's any state, except for those that have no non-discrimination protections, that don't currently have non-discrimination protections on the basis of religion and employment. But were you to find an instance like that, really having those conversations all at once, I don't think that it's necessary or even always appropriate to bring in a Religious Freedom Restoration Act as part of a discussion or a negotiation around employment non-discrimination, for example.
So there may be piece-by-piece ways to do it in certain situations. Nathan, did you want to add anything to that?
I think where we are in this general arena, the more, ironically, the more issues and the more avenues for compromise on the table, probably the better.
So I'm tempted to say that we should adjourn right now because these two have to have a negotiation. Having now said that there may be room for a conversation, we could let them do it right here. But instead I want to go to Robin and talk about this term Riffra and Religious Freedom Restoration Act, which has come up again and again. So broadening the lens a bit, we've had a series of states either pass or try to pass religious freedom acts, which I'm going to summarize this my way. I'm a gay person, I'm biased, but which do nothing for gay people. These are states that don't have anti-discrimination protections, or in many cases, other kinds of protections, but they do pass laws that say they give additional legal protections to and opt-outs for religious folks. Mississippi passed one failed in Kansas, one very narrowly failed in Arizona. I think one just succeeded in Oklahoma, is that right? Did Oklahoma just do one, or Nebraska, one of those states?
I don't think so.
Good, I'm glad to be misinformed about that. So we're seeing those pop. That's a very different track, right? That's a whole different approach to this. What do you see happening, Robin, with this other wave on this other track of RFRAs? And how does it interact with this negotiation track that we just saw in Utah, if at all?
So I disagreed with the governor. Now I'm in the awkward position of disagreeing with one of my co-authors, Doug Laycock, in part. So let me talk about a difference between Religious Freedom Restoration Acts, which I call generalized protections, and the kind of specific exemptions that we talked about in Utah. So a generalized protection is a standard. It's written to ask a series of questions, and it would say, is there a substantial burden on religious practice? Is there a compelling interest for the government to do that? And is there a less substantial way, right? And that's all a way of trying to say, does the government need to kick the bejesus out of religious people just because it can? Okay, there is a good reason to have Religious Freedom Restoration Acts that have nothing to do with gay people, nothing at all. So think about the Amish. It turns out they have these buggies, and they like to have steel wheels on the buggies for some reason that I don't completely understand. And the government wants to say, you can't run those down the highway because, we tell you you can't. Okay, that's the classic RFRA case. Should we try to have some room for the Amish to live out there? This is a religious conviction, don't ask me why, but should we have some room for them to try to do that without the government just stepping on them? I think the general answer ought to be yes, right? But what happens is you have religious folks around the country who latch on to a Religious Freedom Restoration Act at a time of great social change as a way to say we want to have our faith communities protected as they are. And then they say wildly stupid things, like in Arizona, they would say, we have to have a Religious Freedom Restoration Act to, quote, stave off gay rights. Now look, if you think you're going to get those kinds of protections to stave off gay rights, you're wrong, part one, and you should lose, in my view, right? These are minoritarian statutes. They are really not about the gay rights debate. Now contrast that with specific exemptions. Specific exemptions literally are the line drawing that you just described. They are saying, wow, we want to advance LGBT rights, but we want to draw careful lines so that we don't inadvertently wash out the religious character of religious communities. Now that is actually a conversation where both sides can win at the same moment in time. It's going to be a harder trick to do that if the vehicle that you want to use to protect religious communities and their unique character is a Religious Freedom Restoration Act. You shouldn't want to do that anyhow, as I told the House caucus in
You're saying
Utah.
it's going to be more promising to look for these
Yes.
negotiated agreements rather than these big global frameworks.
Absolutely. And also, look, I mean, frankly, from the side of religious people, the specific exemptions are going to do the work here that the Religious Freedom Restoration Acts can't. Because if I have a specific exemption, like the ones that are in 297 or 296, and somebody says, you know what, you should have served me as a gay person, and I say, well, go back to your marriage retreat, right? The marriage retreats, the counseling, these are like Baptist marriage retreats. And the Baptists want to have people at the Baptist marriage retreat that are in Baptist kind of marriages. There's nothing wrong or evil about that. But if, let's say, for example, a gay couple presented and said, I want to go to y'all's Baptist marriage retreat, you just say, no, thank you, very politely. It's specifically exempted. And if it comes to litigation, you walk into the court and you hand them the 296 or 297 where that appears. You win on summary judgment and it's over. If it's a Religious Freedom Restoration Act, look at all the litigation around Hobby Lobby.
Yeah, it
right?
can go
I mean,
on
just
and
go
on and
for
on.
years and years and years.
So
That is not going to do
we need
for
to get to
religious
questions,
people.
but before we do, there's one more angle I want to explore, which is what looked to me quite innovative in this bill were the protections for speech. Not just gay speech, not just religious speech, but it basically said that if I'm engaged in speech and it's outside the workplace or doesn't affect my job, I should not have to worry about getting fired for it. Ben McAdams was, in the previous panel, was being a little bit modest because this surfaced actually in 2011 in a bill that Ben McAdams, then a Utah state senator, co-sponsored with a Republican. They floated this as part of an anti-discrimination bill. It did not pass in 2011, but it did pass in 2015. Tell us both, you two guys, what you think of this idea of workplace speech protection, and is it important as sort of a way of expanding the box in which negotiations occur? Is it unrelated? Nathan, why don't you go first, if you're willing?
Sure. I think it's great. I think we should have, as expansive, not just free speech, but, it should obviously apply to free exercise of religion also, and we should try to allow people to have as an expansive performance and action in consonance with their conscience, certainly in their private lives outside the workplace, but even in the workplace we should try to have accommodations where possible. I'm always worried when religious freedom gets talked about as freedom of conscience. That was a big debate in the founding era of this country among the framers. Because freedom of conscience means, yeah, you can believe whatever you want, but then when you want to manifest those beliefs in terms of action, well, maybe not. We have a view, my community, and I have a view, and I think others do as well, that of course freedom of conscience has to be protected, but as much as possible within a pluralistic, complicated human society, your ability to act in conformity with those beliefs proactively, or to refuse to do certain things because they violate your conscience, is just as much an inherent right of your freedom of conscience, of your religious liberty, as whatever it is that's going on inside your head.
So you see this as kind of expanding that safe harbor for expression of conscience, religious and
Yeah, and it should
otherwise.
apply. It should apply to not just it should apply to atheists who have expressions of conscience too that are not religiously informed. It should apply to everybody. That's a core First Amendment principle.
Sarah, what was your and HRC's view of that particular provision, the free speech provision?
We think it's great. You know, in an era of Facebook and Twitter and Instagram and everything else, you know, people end up engaging in very public forums that they don't realize are public forums, as I like to tell my 13-year-old on a regular basis. You know, and you know what individuals say and how they express themselves should not be grounds for termination. There are limits to that, of course, but in general, when people are expressing their sincerely held beliefs, and not just in the religious context, but you know, with regards to family writ large, and that is the way that the legislation is written, with regards to sexuality writ large, greater protections are in everyone's best interest. I will caution, though, I'm not sure that in the long run everyone is going to be happy with these protections. I think that these protections will probably allow for a much greater discussion outside of the workplace around sexuality than perhaps people are prepared for. And we'll have to see how that works out.
It may mean that I'm working next to somebody who I find out has published an article somewhere that says something I think is abhorrent. I'll have to come to work and deal with that.
Or it may mean that you come to work and the individual sitting next to you is posting on Facebook regularly about, oh, great, what's the name of the bondage series that's so popular right now? 50 Shades of Grey. Right?
They've all read
and how
that.
they want to check it out in their own lives. That means someone can't be fired for that. I think that that's a good thing, but I do think that there may be some surprises along the way.
So that's interesting. We got greats from both of you guys. Robin, so we can get to questions. One sentence response, is this a first tying this free speech protection to an anti-discrimination bill? Is this an innovation?
Parts of it are. Certainly you had, as Cliff said, labor protections in other contexts. So, for example, the donation to Prop 8 a decade ago.
In terms of tying it to part of this package deal on anti-discrimination?
Oh, absolutely. Tying it to these deals about marriage and anti-discrimination.
So as a way to sort of frame the negotiations and what we're talking about, this is something interesting. So anyway, that's potentially an interesting and big deal. So why don't we go to our audience, if there's anyone who wants to participate. I would remind everybody that they should tweet questions, if they want to the hashtag LGBTLDS with no punctuation. And why don't we go, wow, we've got a lot of people. I'm going to start in the very back, behind the camera, almost obscure as a man in a blue blazer and a red tie.
And Jonathan, I'm back so far you can't even recognize me. It's Gregory T. Angelo, the Executive Director of Log Cabin Republicans. Great panel today. Thanks very much to you and to Brookings for...
That is in the, 3 words.
Oh yeah, Log Cabin Republicans, for those who don't know, we represent gay Republicans and straight Republican allies of equal rights for gay and lesbian Americans. We're really happy to stand shoulder to shoulder with HRC in pushing for this most recent version of the Employment Non-Discrimination Act. To HRC's credit, even after the Hobby Lobby decision, you guys and gals were standing shoulder to shoulder with us to pass that. Obviously, it seems just from the discussion today on the panel that the goalposts have moved a little bit. We do see this Utah legislation as the potential for a template, especially considering federally the fact that we have a Republican-controlled Senate, Republican-controlled House. The Republicans are probably going to control the House for a number of years more. This is to HRC specifically, but I guess to anyone on the panel, what is a reasonable religious exemption moving forward federally?
Treating LGBT people the same as we treat all other protected classes. There are existing carve-outs for religion in Title VII. In addition, the Supreme Court has issued a number of decisions regarding ministerial employees. And for those who are not familiar with this line of case law, ministerial employees don't just include the priest or the minister. That has been interpreted fairly largely to include professors, lay teachers, cemetery workers. So it is a very expansive view of a minister. But that we already have very significant and real religious protections in place. And that we want to see LGBT people treated equally. We are at a moment when the majority of LGBT organizations have come together and are working with Congress on a brand new type of legislation that would address not only employment, but also housing, public accommodations, federal funding, credit, education, jury service. It is a comprehensive non-discrimination bill, and it is this time when it is ripe to begin a new conversation.
And that's a bigger bill than ENDA?
That is a substantially bigger bill than ENDA.
Has it been announced? And I missed the memo?
It has been announced. The Human Rights Campaign came out calling for this bill last July, I believe it was. And Senator Merkley will be the sponsor of the bill in the Senate. And Representative Cicilline has agreed to be the sponsor of the bill in the House. There is not language yet. That is all still being worked out. But in concept, it is there.
What do you think the Orthodox Union thinks about that effort? Oh, here he is.
My organization does not have an official position on the bill yet because we haven't seen a bill text. But what I will say is, to some degree, I think our test will be, to a large degree, our test will be whether it hews to Sarah's stated principles, which is it treating LGBT folks the same as others are treated elsewhere in the law, or is there, because they're doing a separate bill, is there some sort of enhanced treatment? And to unpack that a little, as Sarah said, in the Civil Rights Act, right, the grandmother of all civil rights bills, you have all kinds of provisions for religious exemptions and accommodations and so on and so forth. And is that going to track equally in whatever this new bill is, or are there going to be some discrepancies? One interesting question that I've had has been if the LGBT community is looking for literally equal treatment across the board, why write a separate statute? Why not amend the Civil Rights Act to wherever it says in the Civil Rights Act from beginning to end, thou shalt not discriminate on the basis of race, gender, ethnicity, etc. Add sexual orientation. And the advantage of doing that, it seems to me, is by doing it that way, you don't have to write a whole new section about religious accommodations, exemptions, and so on and so forth. It's all baked into the cake already.
You guys should definitely trade phone numbers after,
I think so.
after this panel. Is there any chance of getting federal legislation in the near future on this? Right, this is like another of these hopelessly stuck in Congress things, right?
I don't think so. I think that there has been dramatic change in the states. I believe that marriage equality nationwide will dramatically change the conversation as well. I actually believe that having marriage equality helped Utah come to this place, right? That it was not a detriment in passing this legislation, but a boon. It took a topic of conversation that has been somewhat controversial off of the table. The American public is also moving rapidly in their views of LGBT people, including amongst conservatives. It's not going to happen this year. It's not going to happen next year.
They could put it on the debt limit.
But
they're not passing
well,
that. So let's go back to our audience. I'm going to discriminate for the back, because they're always discriminated against. A gentleman in the blue blazer with no necktie, kind of a reddish shirt.
Thank you. Matt Bowman with Alliance Defending Freedom. Professor Wilson, you've written extensively on legislation that happened 40 years ago, right after Roe versus Wade. The 50 states and federal government passed specific legislation saying if you don't want to assist in an abortion or a sterilization, not only can't you be forced to, but it's unlawful discrimination to force you to do that. That's a protected class, people who don't want to assist abortion. And even though Mr. Diamond said that's a different context, we've seen in the last year or two the abortion rights groups and the gay rights groups teaming up and saying people who don't want to assist gay wedding ceremonies are like people who don't want to assist abortions. And all of those people, they're the discriminators. They're not the protected classes. And so it seems to me that under that approach, either we should be protecting the people who don't want to assist gay wedding ceremonies the same way we protect nurses who don't want to assist abortions, or we need to start forcing the nurses to assist the abortions. And I wonder how you approach both of those issues as they overlap.
So the audience knows Alliance Defending Freedom is one of the major litigation groups that's active on religious liberty. So these guys are very involved.
Well, thank you for the question. You know, my basic position has always been that both sides need to win, right? So that religious liberty doesn't have to come at the expense of access. And actually, this is a nice opportunity to correct something that we've been saying about the, quote, willing clerks. We are not actually providing a conditional exemption to clerks in 297. What happened is the Utah legislature created a new duty for the first time in Utah law that says that there has to be a forum of last resort for marriage, that forum will be the clerk's offices. So it literally put a duty on the clerk's offices that never existed in statewide law before. And then it said it could dispatch that duty in many different ways. Likely in rural parts of Utah, like the bottom of Utah, like Monroe, where there ain't anybody, there aren't so many people there, that's going to be an authorized celebrant under Utah law. It doesn't even have to be the elected clerk or any employees. And what that tells you is access, right, to marriage, which I think has to be guaranteed to people after the federal decision, whether they like it or not, right, is not coming at the expense of government employees, right, who have been in these jobs sometimes decades before same-sex marriage was recognized anywhere in the world. Now, as you know, that's exactly what we did in the Church Amendment back in 1973. Little hidden in that discrimination language is that there is a right to there's a right to your moral or religious beliefs, quote, about abortion. So if you are a doctor's office that wants to do abortions, you couldn't be discriminated against by the Catholic hospital where you happen to have staff privileges or any other hospital. And if you were an abortion objector, you were given the same rights and protections against discrimination. That's the nirvana point, a win-win for both sides. You see that, by the way, in the political speech provisions here. Notice that those are protections that run to both sides equally. So I can wear my Equality Utah pin to work right next to my cross. Neither party loses.
Did either of you want to add anything on this? The abortion tie-in
I
and
would
all
just
that?
add, I think I agree with the questioner in the following sense. The rubber meets the road for the LGBT advocates community, like it does for other communities, as to whether they're going to insist on, no, because I walked in and because I individually am entitled to be served, you, whoever I walk up to first, must serve me, or whether there's a room for a conversation around accommodation. Again, to borrow from the other context, Massachusetts, not exactly a red state. Massachusetts has a law on the books, and it's had it on the books for a long time, saying that nurses and other healthcare workers do not have to, work on an abortion case or frankly any other kind of case that they have a conscious objection to, so long as there's another nurse on staff or someone else in the hospital can do what needs to be done so that the patient who's there gets the service that they are legally entitled to. There are some folks, I'll leave you out of this for a second, there are some folks in the reproductive rights community that say that is unacceptable. Every nurse must deliver the service as if they had their policy preference. This is something that the patient is legally entitled to. You, as the nurse, don't have a right to legally refuse them because the law says they can get it.
So same principle, both contexts. Sarah, do you want to add anything to that before?
I mean, look, I think within the context of LGBT people, there's two issues here. I mean, one is that LGBT people need to be able to go to the government to get a license and to be married. And they need to be able to do that in a way equal to opposite sex couples who are getting married. And so when there are options to come up with ways where LGBT people are still treated equally to opposite sex couples, there's a conversation to be had. I do think we need to divorce from the conversation, though, individuals who are performing marriages, right? We have never required in any state, including any state that has legislatively passed marriage equality, that a clergy member perform weddings that they disagree with. In fact, clergy members can refuse to perform any marriage that they want for any reason. They can refuse to perform interracial marriages. They can refuse to perform interfaith marriages. They can refuse to perform a marriage because they think the couple's young and foolish and shouldn't get married. They have the right to do that. But there is a difference between performing a marriage and providing a service that goes towards the wedding ceremony or reception. So the florist who is literally selling flowers that the couple is going to carry down the aisle is not participating in the wedding. They are providing a good and a service.
Yeah, this gets us the tough issue that, of course, the big elephant in the room is public accommodations, which was not dealt with in Utah, was not, as I understand it, a pre-existing part of the Utah law, so it didn't have to be dealt with. But in my state, which is the next state over, Arizona, where I know some LGBT folks who would love to get some anti-discrimination laws on the books. Public accommodations are covered, and that's the discussion about the florist, the baker, the candlestick maker, right? So that's the tough thing coming down the pike, yes? Let's go back to our audience. Gentlemen let's go by the aisle here. Light blue shirt.
Thank you. My name is Chris Johnson. I write for the Washington Blade newspaper, and this question is for Sarah. I just wanted to follow up on a point of clarification on what Gregory Angelo asked. When you say that at the federal government, the way it should be is that protections for LGBT people are the same as with existing civil rights laws for race and for national origin for other categories. Does that mean that anything less would be unacceptable in this upcoming bill by Senator Merkley and Representative Cicilline?
Yes.
Unacceptable. So
LGBT people to be treated the same as all other protected classes.
And HRC will oppose a bill that has a narrower religious exemption, has a broader religious exemption than what's existing under Title VII.
Look, we are certainly open to having conversations about potentially codifying existing Supreme Court law because it applies to all protected classes. But, look, the Human Rights Campaign and most other LGBT organizations never liked the religious exemption that was in the Employment Non-Discrimination Act. It was something that groups decided to do over 20 years ago when what equality looked like for LGBT people was very different. What our lives looked like was very different. And it was a bit about grabbing at scraps. The LGBT community is in a very different position today. We do not want to have protections that other groups do not have. We're not looking for special treatment. But we do want to make sure that the LGBT community is on an equal footing with everyone else.
That's a good, clear answer. Let's go to, I think, Nick.
I just have a question from Twitter. Just one second. Question for Robin. What specific exemptions exist in SB 297 for small business owners, if any?
This is Nick, who's with Brookings.
This is from Twitter. This is from Nate
Twitter,
Madden.
Yes, thank you.
Okay, and so the question is, what are the exemptions for small businesses? So this is actually an interesting discussion point that both of our panelists have talked about, which is how unique Utah is in some ways. But one of the exemptions that was already existing in Utah law based on categories of discrimination like race or gender, and now adds to sexual orientation, would be exemptions for small employers that have 15 employees or less. My sense is that that was really a pretty less than 15 employees, but that's a generous exemption in statewide law. Am I right about that in terms of the size of the small employer exemption?
It varies dramatically from state to state.
Yeah.
It's the federal standard.
It is the federal standard on some of the statutes, but my sense in statewide law is that it was more robust than other states. But the point being that the places in public accommodation laws where the bakers that we really do want to think hard about protecting are those small mom and pop businesses where there's an identity between the business and the people that are running it. So for example, I learned in Utah that almost everybody I met had 8 children. If they
Who's
had
tweeting that?
Oh, well, this is true, but I stick by that statement. But in any event, almost everybody had 8 children. Look, if they're going to create a bakery, they're going to want to hire their children without worrying about whether they're going to get litigated for that. So these exemptions are there, and they do provide a sense of security for small businesses, which aren't really the focus of what we're trying to do when we're pushing gay rights and the ability of gay people to live equally in a community. We're not trying to get rid of these small employer businesses either. Now, that's a little different than 297. 297 is actually more focused on the unique character of marriage. It gives guaranteed access to marriage, as we said. It's seamless from the perspective of LGBT persons or any person walking up to marriage. But the exemptions are tailored to things more closely identified with marriage itself, like, for example, the Baptist marriage retreat, that kind of thing.
It is time to wrap up. Would the panelists, who would like to add anything? Well, let's poll the room. My favorite part of the event today. Raise your hand if you think the Supreme Court in June is going to order same-sex marriage nationally or is not going to order same-sex marriage nationally. Raise your hand if you think it will order same-sex marriage nationally. Raise your hand. Interesting. Raise your hand if you think it will not. It'll do something else. It won't order same-sex marriage nationally. A lot of people are abstaining from this one. Thank you all very much for coming. It's been an amazing day. It's good to have you.
Let's have coffee, though. I think it would be really nice to talk. Yeah.